rampant wastage that used to happen. About 3 or 4 years ago, I was requested by the Senate to look for what are the issues bedeviling this university. Prior thereto, I had been involved as counsel in a lot of disciplinary cases that went to the High Court. And those disciplinary cases used to have almost a circular effect. You discipline a student, expel him, and then that provokes a riot at the campus. You do not do that, then again another circular effect. And when Senate engaged me with a student population of 80,000, I started working with the university administration. Prof, at University of Nairobi, there are 8 colleges. No, sorry, there are 6 colleges. Each college had its own independent disciplinary process. So you'd have a college, for example, Humanities and Social Sciences at the main campus, with near to 18 faculties under it. You have another college, say Biological Sciences or Agriculture at Kabete. Each of the 6 colleges would have its own disciplinary structure. Then for the halls of residence, there were 8 distinct. Consequently, Honorable Commissioners, you have, so to speak, semi-autonomous pockets of disciplinary bodies all dealing with the 80,000 students. And of course, what will go to the academic, the colleges, would be anything to do with academic, but for residential, it's what would go to the halls of residence. I studied this, I engaged all the colleges, we had seminars, and we had so many workshops. And then I looked at comparative colleges like Pretoria, Harvard, my former college, LSE, or University of London, and I actually saw what is the problem with this premier university. It's the 7th university in Africa, but they had not got it right. You cannot have a disciplinary process which has no harmony. So what was ailing this college is the fact that there was no harmony in the sentences that are awarded to students. There is no harmony in what is a disciplinary offense. And I crafted a student handbook that was to operate and is to operate across board. So you do not have a student in one college being expelled whereas for identical offense or misdemeanor or transgression, he is just told, do not repeat that again. Consequently, and I say this without any fear of contradiction, the harmony you now see at this university is a direct attribute of the work that we did. I must, of course, acknowledge that I have received tremendous support from the Senate and from all the college principals and all the academic staff. We were able to actually transform what was becoming more or less a perennial problem of indiscipline to now a college where I'm sure commissioners, you cannot recall the last time you saw university students throwing stones along Koinange Street. And I have many other examples of equal kind that I've had occasion to deal with.
So, Senior Counsel, are you the chairman of the board of the council of Nairobi University? Or?
No, whatever work I did as an consultant.
Oh, okay.
I did as a consultant at the request of the Senate. I was reporting to the Senate, and they authorized me to have meetings with any person within the university. So I started off with the academic staff, and then went on with the college heads, and then as we went along, I got across of why indiscipline had become the order of the day.
So just a follow-up question, Senior Counsel. You're going to be leading a workforce of probably like 5,000 judicial officers and judicial staff. So how will that experience then help you to lead this big workforce in the judiciary?
The principles in leadership, Prof, commissioners, apply for a workforce of 20, and they would apply for a workforce like the Boeing aircraft manufacturer. It is all a question of how you are able to be a leader. I should have indicated that later in life, I did a second master's degree in applied philosophy at Strathmore University. In that I learned business ethics, philosophy as a tool, and leadership really clearly understood what you are looking for are the 4 cardinal virtues. The 4 cardinal virtues are prudence, temperance, fortitude, and justice. If you have the 4 cardinal virtues, you'll be a leader of 10, a leader of 100, a leader of 1,000,000. It is not administrative skills, it's leadership. And in leadership, you're looking for the 4 cardinal virtues. And this is an applied principle in all the blue chip companies all over the world. We had an empirical research at Strathmore about who are transformative leaders in all the companies in the world. And what stands out is somebody who manifests in deed and in word that you have the 4 cardinal virtues. I can say without any fear that I have tried my very level best to manifest and to inculcate the 4 cardinal virtues in everything I do. Before I conclude, from the 4 cardinal virtues, you collapse into 2 other, so to speak, abilities that you must work on, which is humility and magnanimity. So from the 4 cardinal virtues, on a day-to-day applications, there must be humility and magnanimity.
Thank you, Senior Counsel. You talked about the vision a little bit when you said that you move from transforming judiciary from access to justice, move it forward a little more. Please talk a little bit about that, your vision, and how you are going to rally all the stakeholders behind you to achieve that vision.
As a consumer of this service, and here I must say that as a consumer I have that little more knowledge because I've been to virtually every court, and we are able to see how that court operates, how another court operates. I've been a victim of delayed judgments, I've been a victim of all manner of things, and with like measure, I have a lot of very good things to say. Before I say anything further, let me acknowledge, Prof, that in our judiciary, we have some of the best legal minds. And I do not say this in flattery, because I have had the occasion in my second master's program to do a research paper on jurisprudence in apex courts all over the world, on very, very toxic or very difficult subjects that happen in our life. This is the end of life litigation. I've looked at America, the Supreme Court of America, Supreme Court of all the countries in the world. We have fantastic judicial minds. What is it that I'll be able to bring which is not there? Access to justice was very well done by the first Chief Justice. Second Chief Justice did as much as he could. But access to justice is both qualitative and quantitative. It's not enough to have courthouses. It's not enough to have many judges and many magistrates and many tribunals and everything. What we now need is another transformative agenda: expeditious disposal of cases. Expeditious disposal of cases is the one that will take Kenya to the next level. It is heartening to hear of cases still in the court being processed in court for 10 years. we should be looking at a possibility of a case, and we can do this, and I've listened to other Chief Justices. I'm a keen listener of the Chief Justice of South Africa, Mogain. And what he's trying in South Africa is a case management system that can process a case from filing to the determination of that case. Why we must have this is because without it, we will never know statistically how well we are doing. That would be my mission and my agenda.
Okay. Thank you very much, Senior Counsel. One last question from me. In your CV, you have said that you have avoided to be a conspicuous consumption person. But please explain what you meant, because looking at your wealth declaration, Mr. Ngatia, I saw very high-end cars. So isn't that conspicuous consumption, or what did you mean?
No, Prof. Conspicuous consumption has many aspects. I meant social circles. I meant that I am not in social circles. I'm not in lots of the new approaches in life. I do prefer to hold to my own. I prefer the solace of being in a library as contrasted to being in a social circles. And I must say I'm one of those lawyers who are not on the social media, any of the social media platforms. I'll prefer to hold my peace, and therefore I indicated I'm not in those social circles. And I do not mean to say that those who are any less or doing any worse. It's a question of choice.
Thank you very much. I will now request Commissioner Mulu, acting CJ, to ask you further questions.
Thank you. Let us conclude the discussion, Senior Counsel, that you have begun with the Chair on and that leadership must of necessity lead to the reforms that we have already begun and which must be continued. And since you appear to admire Chief Justice Mutunga, let me start at that point. On the 19th of October 2011, when Chief Justice Mutunga was addressing the judiciary and the nation at large, he said the following words. And I quote him: "We found an institution so frail in its structures, so thin in resources, so low in its confidence, so deficient in integrity, so weak in its public support, that to have expected it to deliver justice was to be wildly optimistic." Now, we want you to please put that into context, Senior Counsel, in terms of the transformation, not what has already been undertaken, but the transformation that Senior Counsel would progress, were God to grant that Senior Counsel becomes the 15th Chief Justice of the Republic of Kenya.
Yes. Chief Justice Mutunga, I think, was being very philosophical with certain words. Being low in public support, I can see that as a direct attribute of the events 2 years or 3 years prior thereto, where the public support to this institution was at its lowest level, culminating to a presidential candidate declining to have its dispute litigated in court. And with that came lots of other events. And one of the issues that I would wish to deal with, and that is why I would wish to gain public support, is that if a case is filed on 1st January, within that year, it should be concluded. Commissioners have also done a little bit of reading, and we have real life problems in this country. I saw for example, in Costa Rica, an empirical study which has been done. If you get your criminal justice system working quickly, there is an immediate reduction in crime. But here, what we do is the exact opposite. We make our justice system work so slowly. Consequently, there can be a reduction in crime. If we wish to get public support, expeditious disposal of cases becomes a very important thing that we must implement. Deficiency and being thin on resources, I see that happening because it's at that time of Chief Justice Mutunga, I think Judiciary had not had its pride of place in the Constitution. We also have the history we are dealing with. When I was joining Attorney General's chambers in 1980, Judiciary was a department under the Attorney General. And that is why in the Waruhio Commission, he actually makes a direct recommendation. Let Judiciary be away from Attorney General's chambers. Therefore, the transformation journey not only is to divest or to have Judiciary stand on its own under the Constitution 2010, but we also have its own independent funding structures. And again here, DCJ, I would wish to say all those tools are provided for because there is a Judiciary fund. And the Constitution of Kenya only establishes 3 funds: Consolidated, Judiciary Fund, and the Equalization Fund. Consequently, the framers of this Constitution want us to get away from the full judiciary which was there in 2011 to a very robust judiciary, which is where we want or would aim to have this judiciary get into. I see Chief Justice Mutunga's words as words of hopelessness and frustration in one word, because across them it is the hopelessness of the situation that he's being confronted with.
Senior Counsel, then you would of necessity have to take us out of that hopelessness. Are we still there? That was 2011. Fast forward to 2021. Would you still describe the institution of the judiciary to be in a state of hopelessness?
Far from it. We have made such tremendous progress.
And therefore then, Senior Counsel, what would be the role of Senior Counsel, were he to be Chief Justice, to move us from here to a place better than what Senior Counsel would have found by the time Senior Counsel was retiring as Chief Justice?
I see myself being in more or less the same position as Singapore was in 1980. Singapore had a huge backlog of cases. I have done a special reading of Singapore and the backlog of cases. And within 4 years, and everything being equal, I'm a Chief Justice of 4 years. Within 4 years, Singapore did overcome that backlog. But not only the backlog, simultaneously they put in place the process or the system I am craving for, that cases are being concluded within a relatively short period of time. Today, Singapore, commissioners, is being cited all over the world. They do this with some assistance from the World Bank, but I do believe, with or without that assistance, they had the mentor, they had the determination to do it on their own. It's one of the shining examples of what can be done within a relatively short period of time within a judiciary that really is interested in moving forward. So to answer you directly, DCJ, I'll be the Chief Justice that will end the backlog and simultaneously have the expeditious disposal of cases, not as a theory, but as a practical thing. I would wish to see a criminal case started and within 6 months there is a determination. I would not want to be the Chief Justice of criminal cases staying for so long that witnesses disappear and acquittals are because of the delay in the justice system.
Thank you. I think let us pursue that a little. We have the justice chain players. How is my Lord Chief Justice Ngatia going to achieve a criminal determination within 6 months? Will Chief Justice Ngatia force magistrates or judges to go on with hearings where the other justice players are not playing ball? It is advocates who at times will seek adjournments. I'm aware the court is in control or ought to be in control of the case, but there will be genuine reasons for an adjournment. There will be other maneuvers undertaken by the other justice players, the investigator, the prosecutor, so that the case is not ready and therefore not able to be finalized within this period of 6 months that Senior Counsel Ngatia proposes. What then, what then would Chief Justice Ngatia do to actually achieve a determination of criminal cases within 6 months?
Thank you, DCJ. Like everything else in life, it's not a one-man show. NCAJ becomes the first port of call. The beauty with NCAJ is that all the other players are involved. And it has got to be from NCAJ that a determination has got to be made that we must move this country forward. Judiciary actually comes at the tail end in, for example, the criminal justice system. Coming at the tail end, there is very little you can do. The investigations are done elsewhere. The indictment, the charges are done elsewhere by a constitutional office holder. There's so much prior to alignment in court that becomes almost determinative to how long the process will take. So I will do my very best at NCAJ to say that we must take this country to another level. I would want to get as much cooperation from the other actors, because they are real actors in this system, and without their cooperation, there's nothing that can be done. But the unfortunate thing, Commissioner, says this, that the person who gets the blame from the public is not those other actors, it's the judiciary. And when, for example, and I've done this as an empirical study, when adjournments are also sought by the prosecutors, and they are sought over and over again, a month goes, 6 months goes, a year goes, the person who gets the blame is the judiciary. And those who applied for adjournments do not want to say they caused a delay of 1 year. So it's got to be a collectivity. And the key word here is collectivity of action. And that collectivity will be at NCAJ. But here at the end of it all is a question of whether we want to go the Singapore way which to me is the correct way, or whether we want to just stay with what we are doing, which to me is the incorrect way. We must have expeditious disposal of cases.
Thank you. If Senior Counsel were to be Chief Justice, you would have, at the very least, 3 very core functions. There are more, but 3 core. But considering the whole 5 or maybe 6, which would Senior Counsel consider to be the most important role, if that is a possibility, of the holder of the office of Chief Justice, and why would that be considered to be the most important role of the office of the Chief Justice?
As I look at the Constitution, my obvious answer would be the first and fundamental role of a Chief Justice is the head of the judiciary. Being the head of the judiciary has its own far-reaching consequences. You therefore become, so to speak, the titular head, not the real head, the policy head of the entire judiciary. It's by virtue of being that head of the judiciary that you also have the second hat of presiding judge or the president of the Supreme Court. That role of president of the Supreme Court is a role that I have trained myself for. It's a role that can be played or can be assumed by a practitioner of my standing, and the other roles would be the other commissions, this commission being one of them, NCAJ being another one of them, Council of Law Reporting being yet another one of them, and commissioners. I do have that which it takes to be able to have enough time for all those roles.
Which leads me, Senior Counsel, to the next question, and it is the question of balance between the many roles that the Honorable the Chief Justice is required to execute. So how would Chief Justice Ngatia balance between those roles, and what would guide Chief Justice Ngatia in the balancing act between the roles? You have identified that of the head of the judiciary as, to you, the most important one, but that must not make the others suffer. And therefore, what would be the balancing act? Part 1. Part 2, the Chief Justice, and you've mentioned that, being the President of the Supreme Court, must ensure, in my view, that that court works. Must ensure that as the final court, what comes out of that court is indeed final in nature, so that it really doesn't require explanation and so on and so forth. So balance between the execution of duty of the various roles of the Chief Justice to be able to make yourself an effective Chief Justice?
Thank you, DCJ. As head of judiciary, as I indicated, that's a leadership role. And the beauty with it is that in this judiciary, we have very well established structures, statutory structures, which are very well established. And the Chief Registrar of the Judiciary is the accounting officer. It's not my role to try and micromanage that statutory duty. But I do have an interest to ensure that it's well done. So my first port of call would be the leadership advisory committee, because I would want to carry the entire judiciary or to be with the entire judiciary. I will regard that as my cabinet. Being my cabinet, I'll be able to know what is going on in the Court of Appeal, in the High Court, and courts of similar jurisdiction. In all probability, we should also have a magistrate with us. The CRJ is with us. Heads of directorates are with us. I would want to have very structured meetings with all of them, because that is the cabinet. And with that cabinet, because I'm still ultimately the one reliable, I should be able to know what is going on at every level of this judiciary, including the Cathy's courts, and including how many tribunals have transited and what we are doing about it, and including the improvements we can make, like small claims courts and how we get them going. So it's not difficult for me, because I have with me a dedicated team that I do hope I'll be able to work with quite effectively.
Thank you, Senior Counsel.
But if I could explain about the Supreme Court, because you had also asked me about the Supreme Court.
Yes, please.
The Supreme Court, being a collegiate court, I'll be one amongst equals. And what I'll do from day one is to personally call all the Supreme Court judges, and we shall have a meeting as equals. Collegiality, commissioners, does not mean, and I must say this, it does not mean that I impose my views on them. It does not mean unanimity in decisions. That's not what collegiality means. And we, as a Chief Justice, I'll try to have very robust engagements by the judges. I will not stifle them by telling them, look, let's decide this way. Sometimes, in most times, by having individual opinions is the growth of law. But if you stifle it by having unanimity, you are not going very far. But of course, in such certain very divisive topics, like say racial segregation, you'd want to have the entire court with you. But with the ordinary cases that go to the Supreme Court, I would want the individual judges to actually show their best. If I could digress a little, we remember Judge of Appeal Nyarangi, because of his individual opinion in Motorways Oridian. And we cite this to my Lord every other day about Judge Nyarangi said this, and we all remember him for that. In other words, individual opinions do immortalize judges, particularly if they are well done. I'll be able to balance that work because of my deep desire in development of law. Law is my passion. Instead of other pastimes, I would have time, even in the evening, to read and to generate my opinions. And even in that court, the Supreme Court, I'll try to have the same thing, expeditious disposal of cases.
Thank you very much, Senior Counsel. Let's go to a different area now. You must have come across someone called Montesquieu. You will tell us who that guy is. Tell us what he said, what is he known for, and how does that relate with interdependence?
Very good. That cause for me to quickly remember my reading in philosophy. Up to around 17th century, I may be mistaken, maybe a little earlier, man was living in what can be described as state of nature. A state of nature meaning there was no community or there was no law and order. That state of nature meant you are on your own. Consequently, life was very short, very brutish, very violent. Because of living in that state of nature, although lawyers want to take advantage of this, it is actually philosophers who actually saw a need of moving from the state of nature and to live within a community. And the first, if you could allow me, DCJ, before we go to Montesquieu, the first philosopher who saw the need to move from the state of nature to a community is John Locke. John Locke, or either John Locke or Hobbes, it's John Locke, who actually said that much as we want to go to a community, there are certain rights we cannot surrender. The first right we cannot surrender is life, liberty, and property. But we can surrender other rights of protecting ourselves. We surrender them to this community or this body politic that we shall create. So those three rights which could not be surrendered are today the rights we talk about, which cannot be alienated. But soon after John Locke came Montesquieu. Montesquieu said, even as you move from the state of nature, there's something you are missing. The first thing you are missing is absence of a body that can make laws. Because yes, we are moving now to a society, a community. We have an absence of a body to make laws. Next thing we are missing is an impartial judge. The third thing we are missing is somebody to enforce the laws. So Montesquieu, a French philosopher, is the one who is credited the world over by having the separation of powers. Separation of powers is not a lawyer-driven exercise or initiative. It came from these philosophers of the 17th century. That separation of powers was quickly taken over, as well as the three rights which cannot be surrendered, and Thomas Jefferson, as you may recall, in his Declaration of Independence, he ran away with it. And in America, the Declaration of Independence, which was done, I think, in 1770-something, had the three rights. Right to life, liberty, but then he twisted, Thomas Jefferson twisted the property, and he said, pursuit of our own happiness. So the Declaration of Independence of America is a direct attribute of those philosophers. I hope I have answered you fully.
Save for we would like you to say something about what Montesquieu said, and which I think you have sufficiently explained, related to interdependence.
Interdependence, the beauty with interdependence, therefore, even at Montesquieu level, you have the three powers, for lack of a better word. One creating the laws, another one the impartial judge, and another, the third one enforcing. And this became the legislature, judiciary, and the executive. Their interdependence is that you, as the executive, you require the laws to be enacted by legislature. And as a judiciary, you become the impartial arbiter of any dispute that will arise either horizontally or even vertically. And in that, I see, as a matter of fact, that is the same thing that is today known as the separation of powers within our Constitution. The interdependence meaning that you are not isolated. Could I say this? Judiciary is not created for itself. Judiciary is created as a service industry to the people of Kenya. So if it's understood we are service industry for the people of Kenya, we are not created for ourselves, then we become interdependent because the people we are serving are the people of the Republic of Kenya. Both executive, both legislature, and more important, the 47 million or 40-something million of our citizens. That is our core business.
Thank you, Senior Counsel. I have two final questions. And the first one will be as follows. Would you say that the jurisprudence emerging from the Supreme Court confirms the transformative nature of the Constitution, or it belies it? And while still at the Supreme Court, the Supreme Court has exclusive original jurisdiction to hear and determine disputes relating to the elections of the office of the President, arising out of Article 140 of the 2010 Constitution. Please, with the reference to Section 83 of the Elections Act, the various amendments thereto since 2016, and any other relevant jurisprudence that comes to your mind, Senior Counsel, please discuss the role of the Supreme Court in the nullification or confirmation of a presidential election. And please tell us whether that jurisdiction should rest in the Supreme Court, and what the challenges of hearing that important case are to the judiciary as a whole.
DCJ, you put me in a small fix, but I'll navigate. I'll definitely navigate these very difficult areas. The first one is easy. Supreme Court has come up with some very transformative judgments. Very, very transformative. Let me say this. The Murwateto case, although misunderstood and misapplied by courts in Kenya, has won the pride of place all over the world. I do not have, but I can provide to the Chief Registrar. I was just going through my searches around Murwateto. It is quoted with approval in Barbados. A whole paragraph of Murwateto is quoted with approval. Not just Murwateto, but a whole paragraph of how the Supreme Court came to arrive at a decision that a mandatory death penalty is an illegality. But having said so, I think I could say a word or two about it. In Murwateto, which I had occasion to argue, the question was not about death penalty as such. The question was about a colonial relic. In 1938, the colonial masters inserted Section 204 in the Penal Code. They did the same in other colonies, in Malawi, Zambia, Belize, a few other colonies. But at the time of independence, those other countries had amended their law. But in Kenya, 40, 50 years later, we still have this Section 204. My attack was on a mandatory death penalty, not the question whether a death penalty is constitutionally viable. It could be viable. But a mandatory death penalty means that we are sharing our judicial power with the National Assembly. Judicial power cannot be shared. The unfortunate thing, commissioners, is this. I think Supreme Court didn't make it as explicit as it could that this applies only to Section 204. For the simple reason that Supreme Court thought you can bring into place other actors like Attorney General to come with proposals. Hopefully after they have come with proposals, then Supreme Court will give further directions. As fate would have it in this country, there is a word called lethargy, and after a year, the year that Supreme Court thought that the report will be there was no such report. I lost track with the Muruateto case. But I do know as a fact that what Supreme Court would have wanted to do was not done because the other players in that who are defined by name failed to do that which they were supposed to do. But it's not too late. In the event that you honor me with this position, I'll immediately get to Muruateto, see how the judges who could hear it or to come to terms with how we now do not allow it to be a way of people running away from what are otherwise valid sentences.
Muruateto Senior Counsel is one case. Another one that is transformative?
Another case which would have been transformative but didn't become as transformative as I thought was the arbitration appeals. Because we lost the opportunity of Kenya attracting arbitrations from all over the world like other countries have. That case was going towards making arbitration insular from judicial intervention. The Supreme Court almost reached there but backed out by saying that go back to Supreme Court and let Supreme Court see whether it was. So those are the two that would immediately come to mind. As regards, could I start off with the 2 days case discussions and case conference? And they remembered they have not had their case on the 14th day. So the presidential petition was not heard. It was not heard because they started saying that can there be extension of time? Needless to say, the law for the successful party said it's cast in stone, it's cast in the Constitution. So I do not see that as a major problem. Section 83 DCJ in 2013, it was applied fully. It's on the basis of Section 83 that the election was upheld substantially. Come 2017, there were difficulties. The court, the majority decision did not apply. As I remember, Section 83, dissenting judgment, I believe, of Supreme Court Judge Joki dealt with it. But then there was an amendment by National Assembly. Many things were done. The amendments have been struck off, I remember, by one of the petitions by Katiba Institute. So we are in fairly murky waters about the application of Section 83.
We should start hearing that case, Senior Counsel.
Sorry?
Which court should?
A presidential petition, I would, without reservation, say, should be the sole preserve of the Supreme Court.
Reasons?
We have a lot of similar jurisdiction. Malawi, as you know, has the similar jurisdiction. They nullified the presidential petition, I think, last year. If we do presidential petition in any other court, then there will be issues about appellate processes. I do believe Supreme Court has won its pride of place by having dealt with 3 presidential petitions, and in all 3, the actors may have had reservations, but by and large, it's now an established jurisprudence of the Supreme Court.
Now, to my final question. Right now, as we are sitting here, there is the debate whether or not the 15th Chief Justice of the Republic of Kenya ought to come from inside or from outside, the insider-outsider debate. What is your view of a practitioner, in effect an outsider, at this particular time coming to head this very important institution? Justify your answer with some basis, and that will be my last question to you, Senior Counsel.
Thank you, DCJ. Maybe let me start with the last. United States of America, which has the pride or prides itself as being the most liberal democracy, from 1896 to 1953 had racial segregation as part of its judicial policy. Schools were on racial basis. A black boy, black girl will go to a black school. Similarly, a white girl, white boy will go to another school. Public transport was in the same way. Supreme Court in that country was divided for over 70 years. They had several judges, eminent chief justices. They could not see that segregation is an archaic practice. 1953, General Eisenhower nominated Warren as the Chief Justice. Let's look at Warren. Warren was a very successful lawyer, had conducted numerous prosecutions in the United States of America. He was one of the most brilliant lawyers America had seen. He then transitioned to be the governor of California. Was a governor, I think, for 2 or 3 terms. In 1952, this Warren man was so popular he thought he could stand as a president and sought the nomination of the Republican Party. He was defeated by Eisenhower. He subsequently became the Chief Justice of the United States of America. I emphasize this insider-outsider difference, how difficult it then becomes. Warren is coming from a lawyer who became a governor. He's never held a judicial position, didn't have the longevity of private practice like I've had, and he became the Chief Justice. And then the question came in his court about racial segregation. Brown decision. Warren marshaled all his colleagues and they had a unanimous verdict that there can never be racial segregation in the United States of America. Something that had been unable to be done by chief justices, career judges who had been appointed as chief justices. Same Warren, you remember in the next case, Loving against Virginia, you could not marry across racial barrier. A black boy could not marry a black girl. And Warren came with this very beautiful sentence that love resides in your heart. And no state has the business entering your heart. Unanimous verdict. He managed to defeat racial segregation in the United States of America by his judgments. Look at the first judgment by Warren. This of racial segregation in public schools and transport, 12 pages of brilliance.
All right, Senior Counsel, we have heard about Warren. Now tell us why the Are you saying the outsider therefore is better than the insider?
No, I'm not saying there's anybody who is better than the other. My point is this: please look at merit. Please, let's not have this distinction in JSC as my plea to you that there's anybody who is an outsider, there's anybody who is an insider. The hours I have spent in judiciary before Supreme Court came here, this was our High Court, Honorable Commissioners, this was our High Court. I've spent more hours in the library here, I've spent more hours in court here than cumulatively a few judges have spent in their judicial life. In other words, I do not see it as a correct description to call a practitioner an outsider. I prefer you call him a consumer of judicial service. No, definitely not an outsider. I'm as much part of you. I hope I will not be rejected, as much part of you at all times, because I'm a consumer of your service and I represent the people who actually become the beneficiaries of judicial service.
Thank you very much. Thank you, Chair.
Thank you very much, Senior Counsel. Just a small clarification. I took an interest in your answer by the question from DCJ on this philosopher called, is it Montesquieu?
Montesquieu.
Yes, and you answered very well. You answered very well, really giving an academic answer. And my question is, Senior Counsel, is this philosopher someone who, in a lawyer, would remember what they said from their judiciary philosophy class, or is it that you read a lot of philosophy?
Professor, I will say this without any fear. I did a bachelor's degree in law, University of Nairobi, a master's degree in law from possibly the second best university in the United Kingdom. We never learned philosophy. I learned philosophy in Strathmore in my second master's. Philosophy therefore becomes one of the most important tools that you must have, particularly if you're going to any leadership position. Montesquieu and all other philosophers, Thomas Aquinas and everybody from medieval times. And if I could, with your permission, the first trial was of Socrates. And in all probability, my Attorney General may recall the first trial in 399 BC was of Socrates in the city of Athens. And those are the things you learn in philosophy. It broadens your knowledge, it broadens your judicial approach, and lastly, it gives you a very complete world view of the law and the people that you are to serve.
No, that's okay. I just took an interest because of the way you answered it, but now...
Thank you, Prof.
I now request Honorable Commissioner Mohammed Wasame Judge to continue the technical questions.
Thank you, Professor. Senior Counsel, from what you have stated, you are a successful advocate and you have practiced law for quite some time. I want to know and understand what motivated you to apply for the position of CJ and what you are looking for and what values, both in terms of administrative leader, jurisprudential leader, you bring on board.
Thank you, my Lord. Chief Justice before 2010, I would not have been interested. Chief Justice after 2010, I'll be interested. Interested to serve. I emphasize interested to serve for the following reasons. Post 2010, the Chief Justice is really a leader and a transformative leader. A leader who will never take us back to the state of nature that we almost experienced in 2008. A leader to take this country to a level that we can now compete with our equals in the world. What values do I bring? My Lord, I bring the following values. Ethics is one of my core attributes. I'll bring ethical values into this judiciary. Ethics not in terms of saying do and don't, but to inculcate a culture that we know we are there to serve. To inculcate a culture of correct work ethic. Correct work ethic is not something you legislate. It's something you almost, so to speak, fellowship with the fellow judges. And we agree that really let us be servants of the people who have given us this power. This judicial power is derived to us or given to us by the people of Kenya. We are trustees. Let us not abuse that trust. I'll bring all those values. I'll bring the values of hard work. Allow me to say this, my Lord. In this career that you have referred to as successful, it is a career that I have managed because of one word: perseverance. And for any lawyers, wherever they may be, young lawyers particularly, I would want to tell them this. This legal career, if one is starting, you do it brick by brick. There are no instant successes. And equally for the judiciary, I would wish to have discussions with judges at JTI and to see that really by peer review we can even improve our reasoning in judgments and rulings. Those are some of the values that I believe I'll bring. I'll bring that value of continuous reading of beyond law, philosophy, and other disciplines. Thank you, my Lord.
You have also talked about the impressive CV of Mutunga and Maraga, what they did as Chief Justice. Because of the 2010 Constitution, having served also in the judiciary even before them, I was also very impressed with Evans Gisheru as Chief Justice. That's for your information. JSC is looking for a Chief Justice who can take the judiciary to the next generation. After Mutunga, after Maraga. I want you to share with the Commission, from your experience and knowledge, 3 institutional weaknesses, if any, in the judiciary that you will address so that you can take the judiciary to the next level. 3 institutional weaknesses.
Before I go to the 3, my Lord, Chief Justice Gisheru and other Chief Justices also did beautiful work. I was here when Chief Justice Madan was the Chief Justice, Chief Justice Coker. I have worked under them. They did wonderful work under difficult circumstances. But those circumstances are no longer with us. The structural difficulties which were there are no longer there. Some of the, and I say this not as a condemnation, we still have weaknesses in delivery of or conclusion of cases. Conclusion of cases is still bedeviling us in a very major way. Hearing of cases is also something that is still a challenge. ICT, as my Lord is aware, we have done, and I must say this, it is my heart to judiciary, we have overcome the mental barrier. Most of us had a mental barrier that ICT cannot work. We have overcome that barrier. We now know ICT can work. All we need to do is add capacity, and we are almost there. And with ICT, with other human skills, human resources, will be more or less on the way to the next level.
Thank you very much. Now let's go to the difficult issue. This is RILA 2013, which in my view spearheaded a critical legislative reform in the election laws that included the incorporation of technology in our elections. But one of the critics of that decision is what the court called the timely filings of election petitions. And you were involved in this case. The court rejected that voluminous affidavit by the petitioner, which was filed, in my view, within which was not filed within the it was not filed with the petition, but it was filed before the determination or the hearing of the petition. Are you a Chief Justice who will give broader interpretation to filing of petitions, such that if somebody feels he has filed the petition within the 7 days, but there are critical issues which needs to be brought before the court, and is brought before the determination of the decision, are you a Chief Justice who will allow broader determination, broader interpretation, such that justice is served to all litigants who come before the Supreme Court, especially in presidential petitions?
As you indicated, is a difficult question, but we can actually answer this on principles of the Constitution. The first principle, my lord, is that we have 14 days for Supreme Court to decide. Or let's start a little earlier. From the declaration of the result, an aggrieved party has 7 days, 7 solid days. Put your act together. So the petitioner has a very big advantage, and I would want to be understood in this very well. Petitioner has 7 days from declaration of result. A petitioner who is desirous or who considers that his vote doesn't work well, I'll be petitioning Supreme Court, has another almost 5 days at Bomas of Kenya, where collation of results is taking place. So cumulatively, a petitioner who is diligent has 12 days to put his house together. The respondent has a very short period to answer hundreds and hundreds of volumes of pages. And my lord, as you indicated, I've had the advantage, or I've had the privilege of handling this. It is not once or twice. I had, together with my legal team, less than 2 hours of sleep per day, because you are dealing with massive accusations, massive innuendos, and massive everything. So the respondent actually is disadvantaged. By the time of filing this, you have Supreme Court, per the Constitution, has 14 days. My lord, let's agree that is cast in stone. It's not elastic. If you are to allow the same petitioner who had 12 days to put his act together to be able to come with another affidavit that would require me another 3 or 4 days to respond, my lord, you take us to Zambia. We go directly to Zambia, where the judges realized on the 14th day that our time is up and we have not had these characters. It's a dangerous thing. So, my lord, it's not even being broader interpretation. It is simply this. Unless there is any amendment, the 14 days is the day that Supreme Court must hear and determine. So you cannot have the luxury of allowing one party more latitude than the other. Allow me to say this, my lord. If further affidavit was allowed, principles of natural justice, I would have been given corresponding time to respond. If I'm given corresponding time to respond of the 14 days, then we'll start a hearing on the 11th or 12th or 14th day. It's not possible for a hearing to be done.
Okay. Another critique leveled at the court in 2013, the Raila case, is that the court is allowed within 14 days to hear and determine the election petition. but on the 14th day or on the 13th day, the court renders one paragraph judgment. In essence, people are saying, and the decision is rendered maybe after 1 month or 2 months, the court is enlarging the constitutional timelines by not rendering the full and the final judgment of the court. Are you a Chief Justice who will ensure judges of the Supreme Court render their judgment on the 14th day or on the 13th day as provided for under the Constitution?
Yes, my Lord. And this depends really from, now I speak as a practitioner, different styles by judges. I've been before quite a few of your brothers and sisters, particularly of yesteryear, who at the conclusion of the case will come up with a decision of the case and say reasons to be provided later. I've had that experience. And I'll agree with you, the problem with that is this. I do not know for certainty why the decision went the way it is. I think the middle ground is this. I'll borrow heavily from Warren. You do not need a PhD or a master's as a judgment in any case. In Warren, in the Brown case, it was a 12-page, and it was sufficiently well-reasoned to be a judgment. If given the opportunity as a Chief Justice, I would endeavor to my utmost to have a reasoned judgment within the 14 days.
Again, let's come to Raila 2017, Raila 1 2017. The petition was invalidated on the interpretation of Section 83. And the court accorded the section a disjunctive interpretation. Given the use of the word or, and then later after the decision there was an attempt by Parliament to replace the word or with under, which was rejected, as you correctly said, by the Court of Appeal through an application made by Katiba. As a Chief Justice, are you a Chief Justice who, because the Supreme Court is allowed through majority decision to depart from its earlier decision, are you a Chief Justice who will depart from that position because your position that time was the conjunctive interpretation should be given to Section 83? I know it's a difficult, but you have the liberty to answer.
My Lord, you place me in an awkward situation where, probability, the emerging political formations are listening to this. I'll approach that court with a very open mind. Neither conjunctive nor disjunctive. I'll listen to them, oblivious of what my arguments there before were. And there's a lot to be said about this. The moment I take my judicial office, my oath of office, it becomes a divorce, the cut of the umbilical cord between Ngatia, practitioner, and Ngatia, Chief Justice. It is a dicey issue, or has been argued, and I have argued, or can mean as an and it has been argued to the contrary. I'll be a Chief Justice who listen to legal arguments, oblivious of what I may have argued before, and rule in accordance with the Constitution.
Okay, let's come to the simple issues. In your first annual address, the Soja address to the people of Kenya, tell us 3 messages you will convey to the people of Kenya in major areas that you feel the judiciary is lacking or is of concern to you.
I will not approach the people of Kenya with an alarmist statement that the judiciary is lacking anything. My first statement will be that you have a judiciary that is capable and has been delivering very good service. I will be actually, as Chief Justice, will tell the people of Kenya, we are here to serve you. But I'll go further and indicate areas that we shall progressively work with them and make this judiciary even more profound in their day-to-day activities. I'll tell them the days of paying cash at the registry are days gone. We do not want so much interface with people. And I'll tell them in 2011, the revenue that we collected is 500 million. Last year, I think it was 2.8 billion. So I'll tell them, let's have more faith in technology. It's much easier for you to pay through an M-Pesa. I'll also tell them that there's this perceived rot in the judiciary, your file is missing. We are going to work together to have a digital filing system, the e-filing system. And I'll tell them that very soon we'll try to have even courthouses to be able to do e-filing for litigants in person. And I will explain to them the beauty with e-filing is that from the comfort of your phone, you can see how your case is progressing. In other words, my Lord, I'll be not a Chief Justice to condemn judiciary. I'll be a Chief Justice to show Kenyans that we are here as their servants and we are going to take this judiciary to the same level, if not higher, than what Singapore has achieved.
Thank you. And lastly, Senior Counsel, your solution for the 41 judges. And I wish you well.
My Lord, 41 judges, they are now 40 out of attrition. There are many solutions to it. The solution of a discussion would be the best. Failing a discussion, I would do my very, very level best. But my message would be this. I need all hands on deck. Without hands on deck, I will not be able to achieve. So the approach would be, let us find a solution. Let's not do so much with the legalistic positions, much as they may end up with the result or the other. I would say, I need hands on deck. I am a captain, I'm handicapped, and there are difficult winds ahead, difficult storms ahead. I need all hands on deck.
Thank you, Prof.
Thank you very much, Judge Osama. Thank you, Senior Counsel. It's now the time of Honorable Judge Majaja, Commissioner, to continue the questioning.
Thank you, Chair, and welcome, Senior Counsel. I am looking at your sample writings. You presented 6 of them, some of the cases you have done, and 2 dissertations. And I would praise you that they are very, very well written. But before I touch on some of them, I just want to follow up from where my 2 colleagues have left. Starting with what the acting Chief Justice spoke about, insider, outsider. Kenya has had, the judiciary has been in existence in Kenya for over a century, 1897 up to date. We have never had a woman Chief Justice. So the issue now we are confronted with is to say this position must be for a woman. Just the way there are those who are saying insider, outsider, there are some who are saying now we want a woman to be Chief Justice. So what is your response to that?
As my Lord appreciates, I've never had the honor to be in a decision-making forum like JSC. Notwithstanding, let me go back to what happened not very many years ago, within our lifetime, 1963. Kenya was at the same level with Ghana and with Singapore. Same level, we were at par. Singapore said we are going to have meritocracy as our guide. Kenya and Ghana did not. Singapore, within our lifetime, is in the first world. We are still in the third world. And our brothers in Ghana, still in the third world. I will not be gender-driven in such an important process such as this. I am not here to say that a lady is not sufficient as a Chief Justice, but I'll look for a leader, be it male or female. I will not, so to speak, discriminate, because by discrimination I would have even gone against the Constitution. The most merited person, be it a person of disability or whatever, is what I think JSC would go for. And I keep on repeating Singapore because these are things, transformations in that little place that have happened within one lifetime. There's no other country that within one lifetime have moved from third world to first world. And I listened to the Prime Minister, the 5 secrets of Singapore. Secret number 1 is meritocracy. Secret number 1, meritocracy. So here I am to answer you directly, my Lord. If I was looking for a judge, I'll look for judge so and so who fits that description, because it's the legal mind I'm looking for. Be it a lady or a man would be a secondary consideration.
Okay. I note you have also read a lot of philosophy. I haven't. That's why I'm unable to engage with you at that level. But probably tell us one female philosopher, one female person who has done a lot of ethics that you think has made an important contribution to this area of law we are dealing with.
There are quite a number of lady philosophers. I may not recall them by name, but even at Strathmore, my lecturer, who I think is the head of the department, is a lady. I'll try to remember her name. Gishura, I think.
Okay.
Professor Gishura, a lady. One of the very best philosophers that ever taught me.
Okay, thank you.
Yes.
The other question which arises from what the chair talked to you about, what the chair raised, and what we were talking about, the next generation. In my view, the next generation of this country is the youth. We know, for example, 60%, and maybe I'm wrong, maybe I'm right, 60% will be young people under the age of 35. In fact, it is projected that for the next 10-15 years, we will have a very youthful country. And that presents to the next Chief Justice a huge challenge. Because you have to you say you are a service, you have to cater to that demographic. I was a bit concerned when you say that you use the word ostentatious. There is a word you used that says you are closed, you are not part of social media, that is for other people. But one of the threats judiciaries worldwide and states have identified, and even our Supreme Court has identified, is the whole issue of information and disinformation in this age. Given your position as the Chief Justice, are you the kind of Chief Justice who is willing to engage on that platform that is accessible to what is now the majority of Kenyans?
Thank you, my Lord. Supreme Court of United Kingdom, and I'm sure my Lord will be able to see this during the break. Supreme Court of United Kingdom has possibly the best web page I have ever seen. Supreme Court of United Kingdom. With the click of a button, you are able to see all the outstanding cases. all the cases that have been decided, and actually what the holdings are. It is something we must try to have. It's so educative, so interactive, that you can actually go click to, say, a particular case on Brexit or whatever, and even get the lawyers' arguments in that case. That is the Supreme Court of United Kingdom. We must have that.
What about you as the Chief Justice, head of the judiciary, who people look up to?
I was to go to the next thing. Supreme Court of United Kingdom has a Twitter handle with hundreds of followers. My Lord, as a Chief Justice, I'd have no difficulty with engaging. The engagement I think I was talking about are the engagements that you see which are sometimes with respect, very abusive, unnecessary, that have become more or less the nature of the day. I belong to a little older culture that when you leave court, you don't start addressing the media about your arguments and everything. I'm of that culture that had a bit of restraint, because if we do not also have restraint, my Lord, then I don't know where we'll be going to. But if you could allow me to just say one word about the youth. I have a message for you, for the youth, particularly the young lawyers. We have hundreds of young lawyers who have no livelihood. Judiciary must change its style. We must also take part in development of this country. My mission or my view would be that we start having innovation hubs in our courts. All we need is a room, have several desks, have Wi-Fi, and these young men and women can be able to do their research. That is one of the messages I would have for the young lawyers. And of course, start over pilot at maybe Milimani and have it across board.
And finally, just to follow up with what my brother, Commissioner Watsame, spoke about, the 41 judges. And I just want to relate this to an issue of self-sacrifice. Are you willing, if we nominate you to be the Chief Justice, then you're appointed by the President, approved by the National Assembly, are you willing to tell the President, before you swear me, I would like you to swear the 41 judges? Is that a sacrifice you're willing to make as a prospective Chief Justice?
Judge Majanja, one of the cross-examination is very incisive. I do not think it's possible to have a condition spelled out to the appointing authority. I think it will be disrespectful. But at the same time, I'll make it as important as my swearing in. In other words, my Lord, I do not see it befitting to say you must do this before you do this. But I think in the order of priority is to prioritize both events. To say that, please, as you appoint me the captain, you disable me by not having the hands on deck. That way I think would be more efficient and more effective than going with conditions precedent, as we call them in our court, conditions precedent. Okay. So it's not good to go with conditions precedent.
Yes. Another question, and this is on the Muruatetu. I heard you say that Muruatetu has been applied. Am I correct? You said it has been misapplied.
Misapplied.
Misapplied. Can you tell us the instances it has been misapplied?
It's been applied or misapplied in sexual offenses, robbery with violence, and very many other cases.
And why do you say so? The Supreme Court was dealing with Section 204,
I know judicial officers say by parity of reasoning. By parity of reasoning. Also, by parity of reasoning is a tool lawyers use, is a tool with certain shortfalls. Because the parity of reasoning cannot be the same for sexual offenses. Parliament or National Assembly, in my view, is perfectly entitled to say, because of the prevalence of this offense, will give a minimum sentence. And parliaments all over the world have done that.
But you said in your same discussion, the reason why you challenged this law, and again, I'm quoting, you said, your argument leading to the unconstitutionality was that the judiciary cannot share power, judicial power, with the legislature.
Correct.
That is the principle upon which 204 fell to that extent.
Correct.
So, what is the difference between sharing power with the judiciary in mandatory death penalty and sharing power with mandatory sexual, and it's not only mandatory sexual offenses, it's Forestry Act, for example. The old woman who is in the forest, she's found with firewood, and she's told she has to go to jail or pay 50,000 shillings. So what is the difference in the is the issue the principle or the issue the offense? That we can pick and choose the offense, but remain with the principle.
My Lord, there are two different situations here. In murder cases, you have a one sentence fit all. We know as lawyers that no two murders are the same. So to have your life extinguished on conviction of murder, notwithstanding extenuating circumstances, is to have a sentence to fit all circumstances. In other legislations, penal legislations, I am of the view that depending on the prevalence of a particular occurrence, National Assembly may be within their power to indicate, for example, that for this offense, you pay a fine not exceeding this. So it's not a co-sharing of power. What Parliament is saying is that there's so much of prevalence of this issue. But I must also indicate to you, my Lord, that is not something I have ever argued. My arguments were limited to Section 204.
Okay. So I'll just ask now, going back to your readings, which I said are excellent. I have no problem with them, but just to raise a few issues. You were in the Okemo extradition case.
Yes, I was.
And I'm not talking about the merits. This case started in 2011. It started 2011. 2013, a petition was filed in the High Court. 2015, Judge Lenola gave a judgment. You appealed in 2016. 2018, Court of Appeal gave its decision. That's a period of 7 years. And if it went to the Supreme Court, probably it would take 2 or 3 years. So that must be an issue. If you become the Chief Justice, that would be an issue for concern to you, that an extradition case running through the system would take an average of 7, 8, 9 years. Probably just tell us one intervention you would make to deal with this kind of situation, particularly in this kind of cases where international interests are involved.
My Lord, it's a question of sometimes of a good case management. If judges were to conference, you may be able to actually see that the issue raised is a single issue. Without going to the merits, as you indicated, it's a single issue pending for determination in the Supreme Court, namely between AG and DPP, who has the legal power. It's not something that ought to take years. It's a single issue appeal. And I sometimes make my appeal so easy.
So I'm talking about the process. So what would you do in that situation?
It started with the correct case management at the High Court. It was the same issue. It didn't require lots and lots of hours to argue. It was a single issue, and Judge Renaura decided it. He was overruled by the Court of Appeal, and we are waiting now for the Apex Court. Okay.
Then we have the Wajir West constituency petition. That one you lost. You lost in the High Court.
I won in the High Court.
You won in the High Court. Sorry, you won in the High Court. The election was set aside. Then you went to the Court of Appeal. The Court of Appeal said you can't bring new issues. Set aside the decision of the High Court. Then the matter came back to the Supreme Court, and the Supreme Court upheld the High Court.
Yes.
There has been a concern, and this concern is reflected in the quote-unquote BBI amendments, that these election petitions should stop at the Court of Appeal. Is that something you agree with?
I speak now as a scholar. Too many petitions end up going to the Supreme Court. And Supreme Court is not being called upon to determine constitutional issues. A lot of them are really contestations of fact. Those contestations of fact, there ought to be a sieving mechanism at the door of the Supreme Court. So the ones which are dealing with contestations of fact, they are told no, be content, live with it, learn to live with the Court of Appeal decision.
So in actual fact, you're saying that this amendment is really unnecessary. You're saying because the Supreme Court has the jurisdiction to say that this election petition, for example, does not raise constitutional issues of constitutional interpretation and application, and that can be the sieve.
Yes, as my Lord will recall, the open door policy was done through Munya.
Munya, yes.
It's Munya.
Yes.
Munya case is the one that opened all the doors.
Yes.
Before Munya, we were in good comfort zone.
Yes.
But after Munya,
your client would actually have lost without Munya.
Yeah,
but on the larger question, so you agree that in fact election petitions ought to be treated like normal litigation?
Correct.
Yes.
Because they are.
Yeah. So the Supreme Court has the devices to say that, you know, just because an election petition emanates from section whatever of the Constitution, it's a normal case, and you have to show us that in fact.
Very, very correct.
Okay. So say, for example, what one of my professor friends used to say, is there a difference between the governor's elections in terms of general public importance and one for an MCA, for example?
Apart from, of course, the ego, the legal questions are the same, because you are dealing with an electoral process. And dealing with an electoral process, all these must be seen in the same vein.
Okay. Then there is the issue of geochem and geochem Kenya Bureau of Standards. That's one of the cases that came after NUTU and Synergy.
Correct.
Yes, and I'm happy to say that I briefed your senior counsel in NUTU just before I was appointed.
Thank you very much, my lord.
One of the critiques of NUTU, and this is maybe something you will have to address, one of the critiques of NUTU and Synergy is that it actually opened the door to appeals in arbitration cases. How has that affected, in your own view, the general right of appeal in other cases generally?
My lord, Because this is something that is important to discuss and to talk about. Mutual and synergy also argued at the same time, and the decisions delivered at the same time. When you have some time, please look at the holdings in both. In synergy, the final word is go back to Court of Appeal for hearing on merits. That's dispositive, the dispositive part of it. In mutual, which I conducted, is slightly different. We are told, go back to Court of Appeal, but this guy must establish in limine, making it like a preliminary hearing, whether he was entitled or his appeal lies within Section 35. So that's why you see that synergy has been processed by Court of Appeal and determined. Noto has not, because Noto must go through a hearing in limine before it is admitted. So in my respectful submission, a lot of very difficult areas have been within Noto. How will you have this preliminary hearing within a hearing?
And so would you, in your own view, the Chief Justice's dissent would have been a better decision? You shut that door and call it a day?
Well, I won't go as far as that, because I'll be said to have a partisan interest. But the Chief Justice's dissent is very, very powerful. It's a very powerful dissent. And as we have seen in our judicial development, sometimes the dissent becomes the voice after some years.
Okay. Now, you have practiced for many years. And when you practice for many years, you become steeped in the traditions, the arcana of common law. And Justice Willie Mutunga then says that part of our challenge of judicial transformation is common law capture. We are captured by the common law. And for those of you who have practiced, some of us who have written, common law is a beautiful thing, but it is capture. It restrains us from transforming our law, decolonizing. As the Chief Justice and leader of the Supreme Court, what are some of the ideas you have in terms of surmounting the common law capture in order to transform our jurisprudence?
Yes, my lord. The common law capture is because that is what lawyers are taught at first tier system. The first tier being our first interaction with the law faculty. But as we progress, we start finding that that capture or that information we got is not really the correct information. I have traveled and I have lawyers I work with. For example, in India, and actually you may be surprised, my lord, we are not very dissimilar. I think it's Article 20, yes, Article 22, which provides that dealing with Bill of Rights, the court should not be restricted by procedural technicalities. Should not be restricted by procedural technicalities. That is in our Constitution. Despite this, you still find, because of that capture you have indicated, courts here still require elaborate pleadings to be made. In India, we have what they call PIL, Public Interest Litigation based on the Constitution. And that litigation can be done as informally as the court itself, calling for the minister to appear before them and explain a constitutional infraction. So I am not captured, I am within the development of the Constitution that we must now give way to the modern way of doing things. And the Constitution has already given us this.
And in fact, in your thesis, this one on legal difficulty of delimiting the Kenya-Sudan boundary, which is now prescient as we are dealing with other boundary issues. Maybe you would have been the lead counsel, but the but there is a quote here that attracted me, and maybe I'll just read it to you and ask you. Say, sociological and geographical considerations are discussed briefly, not because they are unimportant, but they must be regarded as peripheral to legal consideration, which forms the main thesis of this paper. What I wanted just to ask is, apart from the law, are there other phenomena, other considerations that affect the law that are actually relevant in the way you interpret and read the Constitution?
Yes, my Lord, as I've indicated in that paper, sociological considerations are so important. As a matter of fact, the Supreme Court Act, Section 3, talks of developing a rich Kenyan jurisprudence. So much as we look all over the world, our bearing, or if I want to use navigational terms, the beacon for Supreme Court is to try and develop a Kenyan jurisprudence. So sociological considerations become important, anthropology becomes important. We are who we are because of where we have come from. Those are things that we must start interacting with, because just interacting with abstract legal issues, our apex court will not grow.
And in your other dissertation on euthanasia, again, very well done. I've learned a lot from it. And one thing I've realized, it was an empirical study.
Yes.
And you found that, in fact, euthanasia is widespread, but under the table, widespread. And you were trying to ask, why is it being done? This is the same issue with abortion, isn't it?
Correct.
It's widespread, but it's all under the table.
Yes.
So the right to life is provided for in the Constitution. It is there. It is also, and the right to life begins at conception. But one of the interesting things in the Constitution is that that life may be taken away by written law. Written law. So Parliament has the space to legislate when life can be taken away, and it can actually, if it wished, it could permit euthanasia and other forms of how life can be taken away. But what I want to ask you is this. First, if Parliament passes a law, what are the kind of standards, constitutional standards, values, principles, can you discern from the Constitution itself that law must be judged by to pass the constitutional muster?
Yes, the beginning point is Parliament cannot pass a law which is illegal. Parliament must pass a law that is within the law. And discussing this from the point of the paper that I wrote, allow me to indicate a little bit more. Euthanasia became what it is in the United Kingdom because of a decision by Justice Kennedy in the Planned Parenthood case. I'm sure you're aware of that. In the Planned Parenthood case, Justice Kennedy said that it's within you to decide what you can do with your body. In other words, your body is your self-project. And he used very flowery language to mean a person is like self-regulating and you have every right with your body. And that determination by Justice Kennedy had a direct influence to euthanasia, to abortion, to all the things that subsequently happened. My view is this. Philosophy now comes to regulate our life. Is man a self-project, or is man beyond a self-project? And that is answered in philosophy. If you look at Jeremy Bentham, he considers man to be sovereign. You consider other philosophers, they say no, man is not sovereign, you live within your image. But fortunately for us, we go to our own philosophers. I am who I am because we are.
But you have still not answered my question. My question is, Parliament passes a law. Because this is going to happen. In fact, Parliament may pass a law. There will be people running to your court to say this is unconstitutional. Parliament will not pass a law, but the constitutional, for example, recognizes that there is a right to abortion, and people will still knock at your door. So what are the values? Just tell us what are the values, the principles that guide that line between what you think or what the law or what the constitutional value places on life and what it places on the person. Can you just... That is what
I will be guided by the Constitution, my Lord, because the beauty with it is that it's not so much of a view, but what the Constitution provides. So if Constitution were to say that life begins at this point and life can only be taken away through an act of Parliament, then that act must measure to the constitutional master of a valid law. At what instances could that life be taken?
Okay.
Yes.
Finally, you agree with me that you talked about perceptions are important in terms of independence of the judiciary, in terms of accountability. We must deal with perceptions. So I'll ask you what I consider probably a personal questions. You represented His Excellency the President in the petitions that we have had.
Correct.
So obviously there is a public out there who feel that if Fred Ngatia is appointed as Chief Justice, he's very close to the House on the Hill, and that will affect his independence. What do you say about that?
The first part of the analysis was correct. With respect to the second one, you had a conjunctive about being close. Kenyans, I would wish to inform Kenyans and the JSC that I was appointed in 2013 to lead a team for which I'm forever grateful. 2017, I was instructed to do the same. But despite, and this is important, despite acting for the president-elect in 2013, as soon as the brief was over, I went back to my private practice. And that relationship of me acting for the president never continued. That is why, my Lord, you didn't see me in any lineup for conferment of chairmanship or directorship of state corporations. The president had at no time tried to interfere or influence me in any work that I have done. You would remember, my Lord, as a Kenyan, that not too long ago, actually last year, a cabinet secretary tried to interfere with the election or with the appointment of the vice chancellor of the University of Nairobi. I went pretty heavy on the cabinet secretary, and he conceded his actions were wrongful. In other words, without saying many words, no Kenyan properly informed will see me as being influenced by the president, because during that period of time, I've worked for any Kenyan who has sought my services. I've worked for condemned prisoners, 5,000 of them. I'm actually maybe more popular in a few of those prisons than elsewhere. I've given them a second chance in life.
Okay.
I am not in any way influenced. And let's not forget this, and this is my last word. 2nd August of next year, 6 o'clock, 2nd Tuesday of August next year, at 6:15, in Kenya, there will be a president. And that president-elect will be any Kenyan other than the president of the Republic of Kenya.
Okay, finally. But the issue here is perception. You've propounded the judicial test, but out there people don't propound the judicial test about knowing what they know. They look at you and they say, this one is like this.
Allow me to...
So, let me ask my question, Senior Counsel. So, having known that there is that perception out there, because it's something you will have to live with, isn't it? Having known there is that perception out there, tell us, out of that situation, what do you think are the two issues you consider an impediment to the independence of the judiciary arising out of that situation, and how you intend to resolve them? And that will be my last question.
If there is a perception, and that will be maybe subjective, because many people I interact with see me as Ngatia, the lawyer, not Ngatia, the person who did the 2013-2017 petition. In between, I've acted for National Assembly, I've acted for so many other people. What I would do in the event that I'm honored and allowed to serve as the Chief Justice is to be as clear as humanly possible that in this judiciary, just like I think Chief Justice Mutunga did, the judiciary will be independent to the extent that we shall not be being directed by anybody or authority, but we shall be independent, being another arm of government. And if, for example, because of having acted for National Assembly or having acted for the President, that warmth or that relationship is to bring a speedy resolution, then that will be an advantage to the judiciary, in the sense that I'll be doing that which, or unlocking that which hasn't been done, particularly, say, for example, in our budget process. Thank you.
Thank you very much.
Thank you, Chair.
Thank you, Judge Majaja. Thank you, Senior Counsel. Just to follow up, one thing you said, Senior Counsel, in your defense, that this perception may not be right, the perception of being close to the President as a result of representing him. You said that you have not been appointed as state corporation or chairmanship. So are you telling the Commission that those people who get appointed is because they are close to the President? I thought it's because of the work they do for the public.
No, I think, Prof, sometimes interpretations can go to any level. All I wanted to explain is this, that as soon as I finished my brief, I went back to my private practice, and that is where I came from this morning. I didn't come from any other place. All I wanted to also emphasize is, as much as I'm a Kenyan, please judge me on that basis. Do not discriminate me because of any client that I have acted for, because in the career I've had, I've acted for the high, I've acted for the poor, I've even acted for those who are in terminal condition. Judge me across board. One of the institutions I work for passionately is the hospice. In the hospice, we have terminal patients. I work for them. They are my brothers and sisters. So judge me for who I am. Do not isolate one person and discriminate me because of that. The President, like any other Kenyan, was entitled to legal representation. I'm not ashamed for acting for him. Actually, as I indicated, it was a big privilege and a mark of faith and trust that he could entrust such a massive undertaking on me. particularly in 2013, we were navigating uncharted waters. And I did that navigation and did it successfully.
Thank you, Senior Counsel. Honorable Commissioners, we'll take a break now. Ngatia will take a break for 10 minutes. We'll come back at 11:30.
Thank you, Prof.
Thank you.